Hey guys, welcome back to the channel. So, one of the things I want to talk to you about is, after you make all this money, save all this money, invest all this money, what's gonna happen to your assets when you pass on, who's gonna, take possession of all your possessions, right? Are there any contingencies for the inheritance of your assets? Who's gonna manage the distribution, right? There's a bunch of questions and more, but all these questions have the same answer, right? A living trust, right? Because if you or a family member has considerable assets, it's probably a pretty good idea to create a living trust. I'm going to try and show you all, as much as, I can about living trust, try to keep it simple and not overly complicate anything, right? So first off, like a living trust is a way to handle the management and distribution of your assets after you pass away. As with all trusts, the living trust is a separate legal entity that can be given ownership of your wealth, assets, and belongings. This may include physical things like real estate, bank accounts, savings accounts, vehicles, art, jewelry, stuff like that. It may also include, say, virtual items of value such as intellectual property or mining rights. A living trust is aptly named as it's created while you're still alive. When you create a living trust, you, the grantor, assign a specific person to be the manager of your trust and everything within it. This person is known as a trustee. You also outline who you would like your various assets to go to once you pass on. These people are known as the beneficiaries of your trust. So you're still wondering, well, how does a trust work? Well, let's look at an example. Let's say you own a fleet of, nice cars or a bunch of houses, right? You know, and you want to put those in a living trust, right? So, upon doing so, you, the grantor, transfers ownership of these from yourself to the living trust. Now, these vehicles or all these houses or whatever it might be is now owned by or in the name of the trust. Along with transferring ownership, you've named, say, your son or daughter as the trustee of your living trust. In your living trust, you've also outlined who will own each vehicle or each house, when you pass away, and whether there are any conditions that must be met before the ownership of these assets is transferred out of the trust's possession. For instance, each of your grandchildren will be the beneficiaries of, say, one of your houses, but only once they've graduated college. When you pass away, your son will manage the distribution, of these assets to each beneficiary, according to the terms specified in the living trust. Okay, well, how about some advantages of a living trust? Well, the primary purpose of a living trust is to avoid the probate process when the grantor passes on. The probate process is the process through which a court verifies the legality of the distributions of a person's possessions once they pass on. In most cases, the probate process reviews, a person's will in order to confirm that the will is legal and that the estate may, be distributed accordingly to the will. In the case there is no will, the probate process is the process through which the court decides what to do with a person's belongings. With, say, small estates, probate can be fairly quick, maybe a few weeks or months. For large estates, right, probate might take years. Ultimately, the process length will vary depending on the estate. Additionally, probate offers the opportunity for anyone to present a claim to another person's estate. This is important for those with complicated families or those, say, with past troubles and unpaid bills. If the claim is valid, it must be investigated as a part of the probate process. Items that are in our trust do not need to go through probate. As such, a living trust saves significant time in the distribution of a person's estate once they pass on. Next, a living trust saves money. Probate costs 5 to 10% of the value of your assets. For large estates, this could mean a significant chunk of change. In some cases, a living trust reduces the amount of your taxable estate, as the assets in a living trust are no longer owned by you, but by the trust. Finally, a living trust offers much more protection from the challenge of claims to a person's estate. Okay, well, what about disadvantages? Well, there's going to be a few downsides, right? So, for one, it creates an extra complication in managing your belongings while you are alive. In the creation of a living trust, you transfer the ownership of your assets to the trust and the management of your assets to the trustee. That means that if you wish to do anything with an asset that is in your trust, like selling one of your assets, you'll have to provide proof you are the trustee, which requires having that documentation on top of, your regular identification. And talking about, transferring ownership of your assets, it's got to be documented on the deeds and titles of each asset. You'll need to go through the process of redeeding or retitling all your assets to reflect ownership by the trust. This is just extraordinarily important to make sure you do. Just creating the trust is not the end. If you do not move any of your assets, retitle or rename into the trust, then the trust is pointless since it does not own any of your assets. Your estate planning attorney should help you and provide guidance on all the assets to retitle or rename under the trust. Some attorneys will file deeds for their current clients, others will not be so sure to ask, what you're responsible for. Next, while the living trust can save you a considerable amount by avoiding probate down the line, they're not cheap to set up. A living trust is set up by an attorney, which can cost you a little bit, right? I mean, it's not cheap. Any modifications down the line, they're also going to need to go through an attorney. Well, then, what types of living trusts are there? Well, living trusts generally fall into two categories: revocable or irrevocable trusts. The main difference, is within the terms of the trust and whether they can be changed at any time. So we're going to go a little bit deeper in each one, just kind of touch on them. So a revocable trust, right? So according to FDIC website, a revocable living trust is one in which the terms of the trust may be changed by the grantor at any time. A grantor can add or remove beneficiaries, change the trustee, modify the terms of the trust, or even cancel the trust altogether. A revocable trust does not reduce your taxable estate. A revocable trust is a good way to eliminate the hassle of going through the trustee to manage the transfer of assets, right? Because you can set up a revocable living trust that establishes you, the grantor, as the trustee of the trust, too, right? That gives you much more oversight over the items in the trust. Once the time comes when you no longer feel capable of managing the trust, you can modify the trust to establish someone else as the trustee. Okay, and the second type is the irrevocable trust. An irrevocable trust is set in stone. It cannot be modified or canceled once it's created. An irrevocable trust reduces the taxes of your estate as the assets are transferred permanently out of your ownership as soon as the document is signed. So there's special types of living trusts, right? Designed for certain circumstances, such as like a special needs trust. This type of trust addresses issues that may be faced by beneficiaries who receive Social Security benefits so as to not affect their eligibility for benefits or supplemental income. An irrevocable life insurance trust, it's going to create it to own the grantor's life insurance policy. Well, who should act as a trustee? Well, when it comes to selecting the trustee of your living trust, there are a few different things to consider. While a family member may feel like it's a simple choice, it can also be a very volatile choice. Selecting one family member over another may cause animosity or a rift in your family. A family friend can also be a risky choice, as relationships have the potential to change over time. Many grantors that are worried about leaving their trust in the hands of someone they know opt for a professional trustee instead, such as an attorney or a bank or a private fiduciary. Some of the questions to help guide your choice would be something like, is this person trustworthy and responsible? Will they manage your finances well? Will they act on impulse with them, or do they make well thought out decisions? Is this person diplomatic, or do they act on favoritism and bias? Can I trust them to communicate effectively with the beneficiaries? Do I expect this person to outlive me? Do I expect them to be of sound mind upon my passing? Right? So hopefully this kind of pointed you in the right direction. Maybe this is something like you want to do for yourself and your family, or maybe this is something that you want to talk to your parents about, setting this up. Either which way, I hope you guys got some good information out of this. If you made it this far, go ahead and hit that like button, subscribe to the channel if you're not already. And until I see you guys in the next video, y'all be safe.